Hi, this is Attorney Mike Gravel coming to you from Chicago as usual, and today we've got a fascinating one. It's Dog Days number 3. We're going to go see Judge Simpson. Brief overview for those of you who might not be familiar. It's a couple that owns pit bulls that injure people. The attorney for the man keeps having him assert ownership despite the fact that causes criminal liability for him. It's really outrageous. She might be guilty of capital felony treason. As far as an attorney goes, I'm not sure, but this is a wild one, and it went on forever, but I edited it down, so these are highlights from a 4-hour hearing. Let's do it.
The issue, fundamentally in this case, the last time that we left off was regarding the ownership of the dogs. There's a motion that is pending, filed by Ms. NULL, requesting enforcement of the previous order of this court in the civil case, the initial civil case with just Ms. NULL's name on it.
And that is under paragraph 7.
But those are allegations.
Well, Your Honor.
I mean, quite frankly, those are allegations based upon your client's representation.
Well, I'm saying correct, Your Honor, but these are sworn complaints. These aren't pursuant to 2.109. These are not pleadings. They're not signed pleadings. These are sworn complaints.
Well, but I understand that. But that doesn't mean that every allegation in them is true. Otherwise, there's no need to have a hearing. If I'm just going to accept what the people put down in that hearing, then I don't know why any of us are here, because I just accept that it's true and just go forward.
So the attorney for Mr. Miller starts it off with this horrible argument, and the judge is rightfully frustrated. She's saying that she wants to go after the prosecutor for alleging something that her client said. I can't begin to tell you how crazy that is.
Well, in a sense, the court does, because upon the sworn complaint, the court then issued a show cause.
Which, correct. And that is that these are the allegations that are made. I'm not accepting those as true. Otherwise, there's no reason for me to even issue a show cause.
Well, then the next question, Judge, the court is putting this on my burden. Is it?
I'm not putting it on your burden. Counsel, understand what I'm saying. There's been a complaint filed with allegations. That complaint has to be filed in a certain fashion regarding because of what the statute indicates it has to contain. They have made those allegations. Based upon that, the court then issues a show cause. So I'm not shifting any burdens. I'm not doing anything. I may appreciate the fact that what you're alleging at this point may put Mr. Miller in very difficult circumstances, but that's nobody's fault but his own. I mean, I'd appreciate it, and I'll let you argue, but quit trying to shift the blame that somehow or another this is the people's fault or it's the court's fault. Because at some point, somebody's got to look in the mirror and say, it may be my fault. But you got to go forth with your argument without those sort of pejoratives coming through. Your phone is supposed to be off. And actually, if it goes off again, ma'am, while you are permitted to have it in the courtroom, if it goes off again, I'm taking it. I got 22 cases up here, and I'm going to decide all 22, piece by piece. So it is not a quagmire for me. So how does an affidavit for a search warrant compare to this?
Because it's under policy of perjury. It's attestation as a witness.
Oh my God. Go ahead. I'll let you finish. I don't even know what that last part meant.
I'm sorry.
A party opponent admission of what?
That Mr. Miller's an owner.
Now, I know the court's familiar with it, but police officers are not party opponents.
I know.
Catherine NULL, K-A-T-H-E-R-I-N-E.
Okay, so this is the female in the couple, and her testimony is shockingly reasonable. She basically admits that she owns the dog, and that's been her assertion all along. But I just throw her in there so you can see things going normally for a minute.
Yes, I know, and you will.
All right, Ms. Null, before questioning begins, you do understand that you are a defendant in a felony criminal matter.
Yes.
All right. You had an opportunity to speak with your attorney, Mr. Bernstein, regarding your testimony here today.
Yes, sir.
All right. And I would just advise you that if you believe that there's a question that you may or shouldn't answer, or wish to speak with your counsel regarding that, you need to let the court know so that the court will pause so that you can speak with Mr. Burns. You understand that?
Yes.
All right, very good. You may inquire, counsel.
This law, an application for a license to Washtenaw County for the dogs that it should. Yes. And when you did so, did you do that online or did you go in person? And did the online application process allow you to input more than one owner's name? No.
So when you applied online for dog licenses, what name did you put into the field for owner?
Mike, did you ever hear Ms. Catherine Null or David Miller?
The judge had to admonish her that she effectively had Fifth Amendment available to her because she's got a pending felony charge hanging around here. This is a good friend of the couple that spends a lot of time over there, and it becomes sort of interesting.
Say that you dogs were only Catherine Null, though.
I'm going to object because that's hearsay.
I'd sustain that objection. You may rephrase.
Your Honor, just for the record though, I'm fighting Ms. Catherine Null's motion to enforce an order that would exclude my client. So it would be her admission or lack thereof.
You may rephrase your question.
Okay. Did Ms. Null ever say that she was the sole owner of those dogs?
No.
Connor, we're going to object this to hearsay. Ms. Dunn had an opportunity to question Ms. Null. She called her to ask those questions and asking this witness for an out-of-court statement that Ms. Null made is hearsay.
Response?
I still think it's a part of the commission.
Actually, I'm going to sustain the objection. You're absolutely right.
Okay, so he asked her what the last witness said, and the state steps up and says, this is hearsay. They could have asked her what she said, which hearsay is not a court statement offered to prove the truth of the matter asserted. It's a great objection. He sustains it. Ultimately, I don't want to get too deep in the woods. He allows the guy to answer the question for a limited purpose, which is pointless. But this exchange is good.
Hearsay at this point. If you want to recall her and ask and confront her with the question, then you can. But
Well, Judge, then, it also then goes to a prior,
why do I get an argument from you after I've made my ruling?
well, Your Honor, I do need to preserve the record.
I understand. The record is going to be clear. You may proceed on. But I am not going to have you questioning it every ruling that I make. You may ask your next question.
Okay, may I?
You may ask your next question.
I love that. I've dealt with this my whole life as an attorney. When a judge makes a ruling, you can complain about it one more time like she did here, but rarely. Once in a while. She's just been chippy and contentious from the beginning of this case, from the beginning of this day. No judge is going to put up with that. If you do that once in a while, you're sort of using up your fund. If you question after they make a ruling, you're on dangerous territory. It can be done. They will at times even listen to it, but not here.
And I have an offer of proof that I would also like to expound.
You may ask your next question.
Okay. Did Mr. Miller ever represent you? He owned you?
Objection, hearsay.
Response.
Your Honor, we're talking about Mr. Miller being questioned as to the authenticity of his statements. He has said he's an owner. He fits as an owner under Michigan law. He has consistently said he's an owner. This is a pattern of Mr. Miller's representations that he's an owner of these animals.
So why does that not make it hearsay? That's the objection.
He's just spot on. They say objection, hearsay, and then she comes back with some side argument. There are exceptions to hearsay that are known to attorneys. It's just part of evidence in what you do. You got to cite one of those. That's it. That's what's available to you to overcome a hearsay objection. Or you have to say it's not hearsay, which is ultimately what happens. But again, I don't want to get too deep into it.
Your Honor, because his coming to this court saying he's an owner was not a recent fabrication. He has always held himself out to be an owner.
So why is it not hearsay? Please. What recent fabrication are you rebutting, if that's your basis for?
Well, he came to court, he said he's an owner. I informed everybody about the owner definition includes all that. And yet I'm still confronted with an evidentiary hearing. I don't know why we even need the evidentiary hearing.
Because I ordered it. So you've got to go beyond that.
Autumn Miller, AUDUMNMILLER.
Okay, so this is the daughter of the attorney bottom left, her client. This is his daughter, and she's got some baggage, and it gets pretty interesting.
I listed you as Autumn Beavers. Was that correct as well?
Yeah, my divorce just got finalized last Thursday.
Okay, I apologize. I thought I used your name.
No, it's okay, that's fine, I was,
Okay. Okay. And how do you know that you Mr. Catherine Null or Mr. Davis Null?
Dave is my dad and Catherine is his girlfriend.
Okay. And do you have a dog that was your father's?
Yes,
Okay.
I have Ellie.
Okay. And how often are you at your dad's home?
A lot, I mean, I go see him a lot.
And how often is that?
3 times a week.
Okay. And for how many years have you gone to see him 3 times a week? Okay. And you go to his house that you share with Catherine Null?
Yes.
So about December of 2021, do you recall the dogs they had in their home?
Yes, ma'am.
Okay. You do, okay. Do you recall the dogs' names?
Most of them, yes. I was never good with that, but I think I can name all of them.
Okay, well, what about the 4 dogs that remained prior to the removal in December?
Can I name them?
Counsel, in all fairness, just so that you're aware, you understand that Ms. Beavers has a conviction that involves truth or fraudulent activities and matters involving truth or dishonesty before you go on with further questioning.
No, Your Honor, it was not.
You may want to then talk to her before she goes any further, because that probably should have been disclosed to you. And I don't know, who is your next witness?
Okay, this is just bad on so many levels. First of all, she calls her client's daughter to try to establish ownership, which again makes her client a criminal defendant. That's ultimately the whole problem with the case, and just I can't even fathom it. But then she doesn't realize or know that her client's daughter has a recent felony conviction for a crime involving dishonesty. She can be impeached with it, and it's not good. Also, the judge doesn't believe anything she says, as we see. But she persists.
Mr. Dowell.
You may want to talk to both of them about that, about their felony convictions that just recently occurred regarding truth and dishonesty.
Yes, Your Honor, for the record, this is Ms. Lundy. People got the witness list at 2:30 today. We've gotten it earlier, we can have more time to do this. We're sitting here today. I was able to pull out that information and I can share it.
All right. Well, maybe she should know about that. Man, you may step down because I think you may step down.
Then I'd like to proceed with.
Go ahead.
I love it. He's like, all right, I keep trying, but it's not going to happen. By the way, we're going to get through all this. Hang with me. I'll tell you the disposition of the whole hearing at the end.
How often did you see those dogs that you found?
Over there. Okay, I mean, sometimes I random trips just to go over there and say hi and greet the kids, or, sometimes I go over there and hang out. They're there always.
Okay. And what observations did you make of your father's relationship with these dogs?
My dad was really close with the dogs all the time.
Is the person doing anything with them, for them?
As in, like, feeding them, outside, hanging out, yeah.
What did you observe?
He feeds them and waters them and talks to them and gives them his yogurt cups and all type of stuff.
So you're familiar with how much care dogs need?
Yes,
It's basically a 24-hour dog, especially when they're little, right?
no,
No?
I mean, no, what do you have to do? Feed them all of them, they take care of themselves.
Dogs take care of themselves? Is that what you just said?
You don't think that they take care of themselves for the most part?
I'm asking what you said. You said dogs?
This is a prosecutor. She does a great job, and she gets her to just say that dogs take care of themselves, which is essentially the entire problem in the case. She wasn't even trying. She just answered a question and offered that nugget up, but she jumped all over it.
Take care of themselves?
I guess. For the most part, yeah, you feed and water them and play with them.
Ms. Miller, you had testified that when you were there longer periods of time, you said that it was for holidays, weekends. And then you were asked if that was weekly. Can you confuse or did you understand what was being asked of you? Objection.
Sustained. That's an improper form of question, counsel, and you know it.
Thank you, Judge. No further questions.
You may step down.
Well, here it comes.
Call your next witness. Does she have anything else to say? You know what? Get her.
Just had to run her mouth on the way out the court, apparently.
We gotta bring her back forcibly. Do it. Ma'am, come up to the podium. Ms. Beavers, did you have something you wanted to say?
No, I do not. I'm not understanding why being at my dad's house has anything to do with this.
Well, you may not understand it. I think you know how you're supposed to conduct yourself in a courtroom,
Yes, Your Honor, I do.
and how you should be leaving the courtroom and how you should be coming into the courtroom.
Yes, Your Honor.
All right, so if you're going to remain here, that is my expectation.
Okay.
Understood?
Understood. Yes, Your Honor.
Don't patronize me. Not today. Not today.
Okay. I apologize.
So you can go. Court's going to stand in brief recess.
Wow, that was just incredibly stupid. She said good job to the judge in a sort of sarcastic manner when she's she's this close to contempt. I don't know if she got that or not because they took a brief recess, so I don't know if they handled it off there. I don't see her for the rest of the hearing, but the judge was not happy and shouldn't be. She was completely disrespectful and out of line. Well, there you have it. This wacky attorney continues to try to get her client to claim ownership of dogs, which creates criminal charges for him. And I can't believe it continues on. I will give you the disposition. He does not rule on the issues. He says he will give a ruling next week. There's going to be another hearing. If it's available, I'll probably do it. It seems to me that he's leaning towards finding that the man is not the owner of the dog and thereby getting rid of criminal liability for him and enforcing the prior civil order. I think that's where it is, but we're not sure. He asked them to submit their arguments in writing if they feel like it, and then I think he'll just issue something. That makes a lot of sense. My guess is, and this is typical, there's nothing wrong with this, my guess is he's basically got his mind made up, but he wants to draft a nice order that addresses this because it's gotten a little complicated. So he wants to make sure it's laid out in a good, clear, and concise order. And if he's got a law clerk, that they might have a little work ahead of them in drafting that. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.